a lot of times when you're seeing emails or communications with the board, you always have to assume that someone else is going to be looking at it and reviewing it and making the determination of who is the bad actor,
right?
Who is being unreasonable here. And so an email to a board member or a property manager is not the time to have an emotional rant.
Right.
You don't allow yourself to be bullied. So you present your case, but you have to be even toned and almost assume a judge or a jury is going to be looking at those emails.
Right. It's almost a clinical approach, because I've seen this before. Some of our clients come to us, they have these wonderful cases, and in their email, you see two things. One, you see their point, which is very valid, but it's sort of watered down by just the emotional rant.
Yes.
Yeah. And sometimes you got to look at it. It's like, okay, that's going to be exhibit A for the board.
Yes.
And they're going to use that against you. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson. Welcome back to the show, Bad HOA. Today we have Marty, our producer. Marty,
Hello.
welcome.
Thank you for having me.
Thanks for being here. And today's special is very unique. We're looking at San Diego, so we brought on our expert, Scott McDonald from the firm. How are you?
Doing good. Glad to be here.
Yeah, welcome to the show.
It's always fun to see a new face.
I like this too.
Yeah.
It's mixing things up.
Yeah.
And, San Diego historically has been such a huge market for us over the last 15 years plus. I wanted to really kind of do a deep dive into San Diego.
Yeah.
So no one can do it better than Scott. So again, welcome. So let's jump right in. Let's talk about your background a little bit. Where did you grow up?
So I grew up in Lake Forest, so Orange County.
Okay. And you have spent a little bit of time in San Diego. I think you told me earlier before the show.
Yes, I spent a lot of time in San Diego. So I lived there in North County, San Diego, in Cardiff by the sea.
Oh, beautiful.
Cardiff's awesome.
What is
Cardiff
it?
is amazing.
Cardiff Crack?
Oh,
Have you guys had that?
Yeah.
From the Cardiff market?
I went there a year ago.
Seaside?
Yeah.
That the one?
Yeah. I went there last Christmas Eve to go get it for the family. And that was the biggest mistake of my life.
Was it sold out or was it just
No,
a line?
because it's you go 2 days before Christmas and you can imagine what that store looks like
It's a
because
mess.
everyone wants
It's a small market.
crap. It is a very small market.
I thought what you were going to say is the VG's Donuts. I don't know if you've had VG's
Oh,
Donuts.
no, I have not.
No.
Yeah. VG's Donuts, they're the best donuts on the planet.
All right.
They're very good.
Why is that?
They're really good. They have these maple rounds that we will make it a point to go out of our way to go to VG's every time.
They
Every
have so
time we
much
have a
good food down
possibility.
there. I feel like there's so many good spots.
When are they going to bring the good stuff up here?
Soon,
I
maybe?
think we're in a bubble.
Yeah, I think so. All right. So where do you go to school?
So I went to Pepperdine Law School.
Okay, beautiful.
Another
amazing.
beautiful place.
You picked some beautiful spots, my friend.
Is that the primary objective is just living in beautiful places?
Yeah. Yeah. Pepperdine was great. Malibu was amazing.
Okay.
Good spot.
And then your first law job.
My first law job was diverts from that. My first law job was in Bakersfield.
Wow. Okay,
Yeah.
so you went
I grew up in Orange County, Malibu, at Pepperdine, and then I took my first law job in Bakersfield.
What type of law?
It was at a bigger firm, and I did a lot of different things.
Okay, nice.
Yeah. It was great. It was a great experience. I had a great time.
How
I
long were
learned
you
a ton.
in Bakersfield?
2 years.
Okay, that's a long time.
It was 2 years, and then we moved from there to Cardiff. And the idea is, my wife was pregnant with our second child, and so we moved before my second was born.
And not a bad place to grow up.
Yeah.
All right, so you're at Ellis Carlson Law now. You're representing homeowners against bad HOAs. What do you like most about the space?
So I love dealing with this area of the law because I feel like it's like dealing with a bully on a school.
Right.
You know what I'm talking about?
Yeah,
Where it's
yeah.
like your HOAs have a lot of power and they tend to use that power in ways that can be inappropriate. Not all the time. There's some good HOAs, but there is that tendency or ability where they can abuse that power. And so I love what I do because I can step in and try and stop the bullying.
You fight back.
Yeah.
Yeah. I like that analogy. I've heard that before
Fight
too.
back, or
It
at
is.
least step in and de-escalate whatever the situation may be. Yeah.
Right. Send a message to the board or the bully.
Yeah.
Yeah.
In a lot of cases. All right, let's jump into San Diego, because San Diego is a unique market. It always has been historically. Specific repeat HOA challenges that you see consistently. What's coming out of San Diego currently?
Well, so I think in San Diego, we deal a lot with, there's water intrusion issues. There's a lot of mold issues. And so we deal a lot with that. We also are dealing with a lot of like boards with egos.
Okay. I see a lot of tyrants in HOA, a lot of big personalities.
Yeah, and I don't know how unique that is to San Diego, but that is a common theme that we deal with. I've been seeing a lot out of San Diego lately.
Yeah, I've been involved in a number of cases, especially downtown San Diego with the big condos, condominium buildings.
Yeah.
A lot of the newer buildings, what I've seen, have a lot of problems, a lot of water intrusion with those buildings. Also, I saw a lot of noise complaints, noise issues, nuisance issues, specifically in San Diego. So it's sort of an interesting market in that sense.
We have a Reddit post that you might be foreshadowing, and you have no idea what it is.
I don't read them beforehand. you hold those keys. All right, so let's talk about, how can a homeowner in San Diego really be proactive against a bad HOA? What are their steps? What are best practices?
So I think it's important when you're dealing with an HOA to kind of understand what you're up against. And I think a lot of people are dealing with, so if there's a good board, things can happen and things can be good. If you have a board that you're dealing with someone with an ego or with a power trip, whatever it might be, I think it's important to deal with them in a way that is, you need to be delicate, right? You need to be emotionally aware of the situation and not
maybe political is a way to
I mean,
do it.
it's a situation you don't let yourself be bullied,
right.
You don't allow yourself to be bullied, but you also don't want to provoke someone that has some authority,
Some of these tendencies. Yeah, I think you're, by threading the needle, because you want to enforce your rights. You want to show, hey, I've done my research. You violated the CCNRs or in violation of the Davis-Sterling Act. But, I would always argue best practices is to be very reasonable in your communications.
Yes. So so right there, a lot of times when you're seeing emails or communications with the board, you always have to assume that someone else is going to be looking at it and reviewing it and making the determination of who is the bad actor,
right?
Who is being unreasonable here. And so an email to a board member or a property manager is not the time to have an emotional rant.
Right.
You don't allow yourself to be bullied. So you present your case, but you have to be even toned and almost assume a judge or a jury is going to be looking at those emails.
Right. It's almost a clinical approach, because I've seen this before. Some of our clients come to us, they have these wonderful cases, and in their email, you see two things. One, you see their point, which is very valid, but it's sort of watered down by just the emotional rant.
Yes.
Yeah.
And sometimes you got to look at it. It's like, okay, that's going to be exhibit A for the board.
Yes.
And they're going to use that against you.
Yeah.
So I like that. A very clinical approach, lay out the situation in a way that's not, and by the way, I get why people do it.
No. So
Right?
what I was going to say, so I tend to be very emotional, and so I can understand why they're riled up.
Right.
And I'm not judging them for being upset, because they have every right to be upset.
You're right. So I think it's just sort of overriding that emotion and looking at it more strategically.
Yeah.
Like, how can I lay the foundation, which I start to stack the deck in my favor? So I like that.
And it's very easy for me to give that advice to not be overly emotional. But I think when you're in that situation, it's harder.
It's hard. You got to be very mindful.
It's really hard.
Well, we've said it multiple times. This is at your home. This is supposed to be the place that is away from all the hellscape. And when it's under fire like this, and you have a board member that's causing a lot of grief, it just becomes explosive. You have nowhere to run.
Yeah, I like the strategy of write the email,
give it a minute,
and just look at it the next day.
Let it simmer.
Yeah. Because it's just going to help you in the long run.
Yeah.
Absolutely.
ChatGPT's still around these days.
Not a bad idea. Copy paste and say,
write the scather.
Take out the bad tone and the emotion.
Yeah.
And make it more clinical. I mean, that's not bad. Why not leverage technology?
Yeah, give it a minute, let it simmer. If you're going to rant to someone else.
Right.
Yeah.
Now let's go into common myths, because you do a lot of consulting at the firm. You meet with a lot of homeowners. What would you say is the biggest misconception when a homeowner comes to speak with you?
I think a lot of people feel powerless. I feel like they feel like they don't have a voice.
Right.
And so it's important to understand that there are laws in the Davis-Sterling Act and even the governing documents, the CC&Rs, that are there to protect homeowners and to govern that relationship. So there are laws, and they do have a voice, and they do have rights.
Yeah, I'm glad you say that, because I've come across very hardened business people who come in.
Yeah.
And they're just like, I'm powerless. I have a bad HOA. There's nothing I can do.
Yeah.
And part of that is the emotion, right? Even though they're these hardened, business people, right? When it comes to their home, that sort of goes out the window. And so I think this notion of being powerless, which is a misconception.
Yeah.
When you start to look at the Davis-Sterling Act and you look at the CC&Rs, and just really meeting with them and empowering them and showing, you got several options here. You don't have to take it from the bully, right?
Yeah. You have rights. You have things you can do. You have a voice.
All right.
One of the more interesting things that I've come to learn as being a part of this is that a lot of the violations that I've seen are in the CC&Rs themselves, as in the board is violating their own rules, which I think is a tremendous source of power. It's written out; they're just not following it.
Right.
Yeah. A lot of times you see it where the boards are being very proactive and enforcing rules against the homeowners when they're not following the rules themselves. We see that a lot.
Right?
Yeah.
So here's a good question. So you're a homeowner, you're trying with the board, you're getting pushback, or they're just silent. Where's that line? Where does that homeowner start to say, okay, maybe I get an advocate, maybe I get a lawyer? Where do you say that line, or when does that line crossed?
So I think there's a couple where I'm seeing where it really makes sense to get a lawyer involved is when the communication is broken down. A lot of times people didn't let it simmer. They got really emotional with the board, and the board is getting emotional back.
Right.
And at a certain point, they're just not communicating. They're not able to communicate effectively. And a lot of times a lawyer can get involved. And a lot of times we say we escalate it and try and de-escalate it. Right. So a lot of times what I would say, if the communication is just broken down completely and it's beyond repair, or it seems like it's beyond repair, a lot of times it's a good time to maybe at least consult with a lawyer, see what the options are.
Got it. Next question is kind of fun. It's fun, but it actually is someone's life. So it's not that fun because it's true.
Okay.
But wildest HOA case you've seen?
Yeah.
And you've seen a lot.
I've seen a lot. Yeah. So the wildest one, the one that comes to mind is I had a client, it happened a while ago, but the HOA board was not functioning as it should. I think the board president was very ill. He had cancer. He had other things going on. And my client, he'd been having issues with his roof. It was leaking, and the HOA was not doing anything about it. And it got so bad, it got to the point where the roof actually collapsed.
Oh my God.
Like it collapsed into his bedroom.
That's
he wasn't
terrifying.
in it at the time, but it collapsed.
That is
Thank
terrifying.
Yeah. And so the roof collapsed, common area, so it's a condo, right?
Yeah.
So it's not his roof.
So he couldn't even repair it if he wanted to.
Well, yeah. So the roof collapses and no one's on the other end.
Wow.
Phone calls, emails, knocking, no one is answering.
I mean, the level of dysfunction there is just
for weeks.
Because then you really have a two-step thing there. There you have failure to maintain common area for a very long period of time to a point of compromise.
Yeah.
And then you have failure and
like absolute failure.
Additional inaction on top. I mean, they're pouring gasoline onto that fire with doing nothing.
Negligence, that is just wild.
Yeah.
Yeah. So he ended up repairing his own roof, which you're really not supposed to do because it's common area roof, but he had no choice because no one else was.
His hand was forced.
Yeah. And this happened a long time ago. It's.
Wow.
Yeah.
Well, welcome to Bad HOAs.
Yeah.
he had an open air condo for a while.
All right. Next part of the show, Marty loves. The lawyers are
don't act like you don't love it either.
I've learned to love it. So this is where he goes onto Reddit, that forum, and he pulls a fact pattern. Now, since this is a legal show and we're lawyers, we do disclaim this. This isn't legal advice. This is just general knowledge for the public. But I want Marty to read the fact pattern. It's almost like a bar exam. Give us your take on, and that's why most lawyers don't like it. They don't like verbal bar exams. But give us your thoughts. Again, general, it's not legal advice, but we'd love to get your take on what Marty has scraped up from Reddit.
Verbal bar exam.
Yeah.
That's maybe how we phrase this thing.
Reddit is always spicy, so sometimes I tone it down just a hair for this. All right, here we go. I own a condo in downtown San Diego in a downtown San Diego high-rise, and my downstairs neighbor constantly complains about daytime noise, talking, music, moving items, or working out, despite my noise levels ranging from 25 to 45 decibels. That's very specific.
Very specific.
The HOAs fined me $3,000 under a vague nuisance provision in the CCNRs that simply states, quote, don't be a nuisance, end quote. Yet my noise is minimal compared to the ongoing construction in the building. They even called the police on me for talking loudly at 9:30 a.m. But the officers didn't take it seriously.
Yeah.
I hired a lawyer for a board meeting, but he was ineffective. The HOA has a history of aggressive legal action, spending $90,000 on a previous case where the owner lost and had to cover the court fees. Now they're threatening immediate legal action for future violations. Can they really sue me under such an ambiguous bylaw for making normal noise in my home? Is this worth fighting in court, or is it a losing battle?
Oh, that's interesting. This is a defensive posturing. That's interesting. Most of them we're on the offense here.
Yeah.
So this is defense.
Yeah.
So the HOA is coming after the homeowner for essentially a nuisance, a noise nuisance.
Yes.
And homeowner isn't making a significant amount of noise, so it's just there's really not much they can do other than be silent.
That's their claim.
Yeah, that's what they're saying. There's always two sides of the story.
Yeah.
Oh, that's interesting.
There is a little area that they did say that in that the neighbor underneath them has made many complaints on the previous person.
Yeah.
That lived there.
This
before,
reminds me of
too.
law school. What is it? The eggshell plaintiff?
Yeah. So at the end of the day, so I deal with this quite a bit, actually. This is a relatively common fact pattern. And so this is what happens when the downstore neighbor makes a complaint, the board feels obligated that they have to do something about it. Right.
Right. And simply investigation, right?
Yeah.
That's the next step.
Usually they would investigate, but a lot of times the board thinks they have to do something about it. And so then the board thinks they're just enforcing the governing. And there's this nuisance provision, which is rather vague. What is a nuisance? What is too loud, right?
Yeah. Yeah.
So in this situation, I think they're wondering, is it worth it to fight it in court?
Or it sounds
Or
like,
how would they respond?
or how do they defend in a meaningful way?
Yeah. So I think this is where the communication skills we talked about earlier, it comes into play, where you're looking at, say, look, and this is the situation, this is what's happening, and you try and in those communications, you might let it simmer. You don't get defensive. You don't assume they're attacking your character or who you are,
Right. Even though they might be.
Maybe they are, but you don't assume that,
Right.
whatever it is. So those communications should be not emotional. And when you're reading it, make sure you sound like you're the reasonable person. So I think that's a good way to start. And a lot of times they're saying that's what I did and they're still coming after me.
Sure. Let's assume that.
Yeah. And then at a certain point, are they coming out for the fines? Is that what it is?
He's been fined. He's already been fined. I think it was twice for $1,500 so far.
Those are big fines too.
And so
That's
he's
pretty
at
significant.
He's at $3,000 already.
So yeah. So a lot of times if they're at $3,000, because what happens, the HOA, they have they have a certain amount of power to enforce these assessments and get out of hand. There can be interest and penalties and whatever it might be. So a lot of times what they can do is the homeowner can pay those fines no matter how obnoxious they are, and they can pay them under protest, is what we say.
Right.
Right. And that can just be as simple as on the memo, just put under protest, maybe write a letter to the HOA board. Hey, I'm paying this under protest for the following reasons: very reasonable, very rational, very calm, not calling names. You're not a liar. You're not dirty scoundrel. And then if they wanted to, they could do a small claims action and try and pursue
the reimbursement of those fines. That's interesting.
Because what that does, it could turn the tables. Because what happens is if they just don't pay those fines, it just starts to fester. And the penalties and different things like happen.
Yeah, I agree with that. You don't want to give them, the HOA, the additional ammunition on a case like this. So I think by paying it, you defuse at least that front.
It takes the pressure off.
Right. And, I think if you did bring a lawyer involved, or you get a lawyer involved, because if you're thinking of it like, hey, if I pay the fines, I win in small claims, they're going to come after me for some other thing, right? It's sort of this endless sort of attack on this person's world. So possibly a diffuse play from a lawyer where you try to diffuse it from the lawyer side of things, where maybe you get decibel levels, you get the readings, you cross-reference the city ordinance. Because often, the city will set a sound limit. They'll say, hey, decibels can never go past this, and that sort of sets a reasonable scale. If you get an expert to back it, though, who monitors the house for a certain amount of time,
right?
And if the lawyer can angle that as, hey, it looks like this might be selective enforcement or enforcement without due diligence, you might be able to at least stack the deck in a way where, the HOA is now on notice that there isn't really a violation here.
Yeah.
That could be another way to at least alert them, hey, you know what, you can't just side with this person immediately. We have strong evidence and, third-party evidence that verifies that there's no nuisance in this space.
Yeah.
So that could also be a strategy.
Yeah.
You can almost run them concurrently.
Yeah.
It's so hard because it's, as the non-lawyer in the room of paying those fees almost feel,
Yeah.
I mean,
It's a hard bullet to swallow.
under protest,
Yeah.
but what stops them ultimately? You pay the fees, but there's still no resolve. You know what I mean? The fee's been paid, the pressure's off, but this person still wants to live their life and feels like they're literally walking on eggshells.
Although with Scott's play, though, you're forcing them into small claims, which is horrible.
So I think so at the end of the day, it's not. So that's the way you push back. If you're being bullied, it turns the tables.
Yeah.
So because that's the whole thing. I think it's like if you paid under protest, and usually with the small claims play, I would have them send a letter to the HOA first, like, hey, I paid this under protest. Here's this letter, very rational, reasonable, everything we talked about before. You have a certain period of time to make this right, or I'm going to file in small. You give them a chance to make it right, because you still are sending that message that I will not be bullied inappropriately, right?
And it will be interesting too. You run that play, you get them to small claims. Let's say you prevail, right? You get the $3,000 back, and then the next day you have another notice fine violation.
Yeah,
that's where you could go to maybe phase 2. That's maybe where you do get attorney involvement. So you almost phase it. Phase 1 is small claims. Maybe it puts it to bed. If it doesn't, that's when you lawyer up.
And I think it's less likely they get another one because they don't want to be. The HOA doesn't want to be dragged.
And they
back
just
into,
lost. They just
lost, and they're saying, "Look, maybe we should pick on someone else,
right?
Or maybe we should not pick on anyone," which would be a wonderful message.
It's
for them
throwing
to
a
receive.
punch at the bully.
But how?
Yeah, it turns the tables. It turns the leverage.
If you don't bring on an expert, though, like Luke was saying, or and assess what reasonable amount of noise is, right? How would the courts determine what reasonable is when it's a he said she said situation?
Listen, it's small claims, and no offense to small claims. Sometimes there's good rulings in small claims, but sometimes it's Mickey Mouse court. You show up, and the commissioner, it's typically a commissioner, they like your shoes and you win. They don't like the other person's shoes, so it can be arbitrary to an extent. Without that expert report, it's gonna be very hard.
But I also think that's again where those reasonable, calm, level-headed communications come into play, because that's going to be presented to,
right?
And saying, "Wait, I've had it where it's like I've had it where they say your kids, you need to enforce a no movement rule after 7:30 with your kids." And you're like, "I'm going to tie my kids up at 7:30 and it's just not going to happen."
Put them in a little cage.
And so that communication in front of a small claims judge, they're going to be, no one's going to think that's reasonable, especially if they've had kids.
But if the other side is saying this person, their music is up to an insane degree, they could ratchet it up to inflate what is actually happening, and you're calm and reasonable over here, but the courts could interpret this as just downplaying it.
Well, I think too, Marty, you're identifying the flaw in the system, right? I mean, there's no perfect court. No. There's no perfect bench. You get bad decisions, and sometimes those bad decisions is based upon bad information that's believed. So I don't know if you can ever combat someone falsifying information. What you can do is you can present, like Scott's saying, a very clinical approach, hey, even keeled, this is the situation. If you bring an expert, I think that adds fuel to the fire.
I think, from everything, it seems like the expert is like, that will be the one that pushes you over.
Yeah, but
because in my sorry, I know I'm getting off course here. Then you kind of remove the he said, she said situation.
Yeah.
You have there's actual tangible evidence that they made a complaint while you have noise, decibel meters in your condo. I've
seen enough of these where usually you could, because usually there's text messages or not always, but there's usually, and you can kind of tell by what, usually they're being specific about what you're complaining about. Okay. Like I said, tying your kids up at 7:30, that's not going to be something that you don't need an acoustic test to justify that. So usually they're being specific.
Yeah.
You're playing very loud music at 11:30 at night. That's going to be okay. I can see why that would be problematic.
Sure.
But if it's like, I hear your kids taking a bath at 6:30, it's like,
and it's
you live in a condo.
and
I
it's
heard a
all
child
timestamped.
walk.
I hear, yeah. So they get specific. I can hear your children walking back and forth to the bathroom or whatever
it is.
Or I
yeah.
hear them playing with their toys, and it's like, they're kids, and it's at a reasonable period of time. So my
that's
point is,
interesting. Yeah.
generally what I see is usually the complaints back and forth tell a story that's enough where you, not that you never would need an acoustic text, but usually.
See, tempered my like that. I'm thinking to myself, how are you going to win? In a he said, she said. That's a very interesting point that I didn't consider.
But and again, it goes back to those communications with the text messages. Like if you're like that neighbor saying tie your kids up at 7:30, you might want to pause on sending that before you let it simmer.
Right.
Because that's not going to look good. Right?
Yeah. Yeah, because the courts will see that, and it's an outline. It'll outline exactly.
And that goes back to how do you prevent these issues? Is like a lot, or be proactive about it.
Be mindful of the communications.
Be mindful of those text messages to your neighbors, and
don't rage text. Right? Is that what it's called? Rage text.
I've heard rage text. I've heard rage slamming of doors. There's all don't rage. Yeah,
no rage.
Yeah,
good.
And don't ratchet it up. Don't turn it up a little high.
No. Yeah. Oh yeah. When you're someone. Yeah. That happens too. Yeah.
All right, Scott. Nicely done. You flew through that. All right. Last thing that we do, we do a bit of a rapid fire. This is more about you as a human. Favorite band of all time?
Blink-182.
Oh, that was quick.
Oh, which song though? What album?
Dude Ranch is way old. Do you know what I'm talking about?
That's pre
so
Travis
Blink-182,
Barker.
Poway, San Diego. They're.
Well, I think what was the one before that? Cheshire Cat.
Yeah,
Cheshire Cat.
That's going way
what was
back.
the song? M&M's.
M&M's.
Yeah.
That's a great jam.
All right, that's a good answer, and I think San Diego is going to appreciate that answer.
They're good. Yeah.
Favorite movie?
Swiss Family Robinson.
Ooh.
Oh,
I would love to live my life on an island,
on a deserted island,
with my family and some friends actually. But it sounds amazing. I love that movie.
He added that just like, oh yeah, with my family
and a couple,
just some buddies.
I love that movie. Yeah,
that's a great movie. Favorite hobby thing to do in San Diego?
So my favorite thing to do in San Diego, they in Oceanside they have an event every year.
Okay,
it's called the Supergirl Pro.
Okay,
up at the Oceanside Pier, and it is the largest all-female surf contest on the planet.
Oh, that's awesome!
And I love it. We've got it every year. Since my daughter was like 8.
Your daughter's a huge surfer. I mean,
so
it might be worth mentioning the level of sophistication and awesomeness of her, Avery.
So this is why I love that event. That event, I would take my daughter to that event when she was 9.
Yeah.
And just starting to surf. And she would see these girls and you get to meet them. It's a surf contest with all the big time all female surfers.
Right. And
it's just a whole bands and festivals, and it's just like a lot of girl power stuff. It's awesome.
When is it held?
They changed it a little bit, but it's they actually started doing one in Florida as well.
Oh, they did?
Yeah, and she might be. So now what's beautiful about it, we have all these pictures every year of my daughter since she's 8 with her favorite surfers.
Oh, that's awesome.
And now she's competing in it and I love it.
That's
cool.
It's
that's
my
really cool.
favorite event. And it's a very well done event. It's always super fun.
Awesome.
Okay, have to say then, what's the favorite surf spot in San Diego?
We surf at Oceanside a lot.
Okay.
We surf in Oceanside a lot.
Do you consider
Oceanside's getting a lot of love right now?
Yeah. Do you consider Sano part of technically
really,
San Diego County?
Technically Lowers.
If that's the case, don't tell San Clemente people that.
But it's technically San Diego County.
Yeah. So Lowers, we're there a lot. And if you're counting, Lowers is probably, and that whole region is where we're there more. But Oceanside's great. The harbor.
Yeah.
Is the spot. You get spread out a little bit.
Yeah.
Not have to. A lot of that stuff where we're from, where you're on top of people. It's a Point Break, whatever. It's down in Oceanside or whatever. You can spread out. There's just little peaks up and down the beach.
Nice. I love it, Scott. It was wonderful having you on the show.
Yeah,
hopefully you enjoyed it, and you'll be back. And Marty,
that's fun.
Thank you for producing.
My pleasure.
And guys, thanks so much for watching. Hope to see you soon. And again, if you like the show, like it, subscribe, and feel free to leave comments because we love the comments.
Love the comments.
Until next time.